Welcome back to Disputes and Perspectives. I'm Adam Assar. I'm a partner in the Denver office of Reed Smith. Today, I'm joined with a special guest, Honorable Judge Mark Bennett, who is a former federal judge, now a mediator, who has had years of experience both in practice on the bench and now on the other side as trying to resolve disputes. And we've got a lot to talk about today. So, Judge, welcome to the podcast.
Thank you so much for having me, Adam. I'm very glad to be here today.
For the audience benefit, let's just reset a little bit. We've obviously mentioned you were on the bench for a period of time. How long were you on the bench for, sir?
I was a United States Magistrate Judge for 2.5 years and a United States District Court Judge for 24 years.
What district?
The Northern District of Iowa.
When did you come off the bench?
6 years ago.
Since then, what have you been doing?
I've taught full-time at Drake University Law School and started a mediation, arbitration, and legal consulting practice. I recently completed my 623rd mediation, and I do about 12 arbitrations a year.
Do you prefer arbitrations over mediations?
No, I prefer mediation.
But let's go back to your time on the bench, because we're always interested in hearing from the mind of the decider. And it's a challenge because judges in particular sometimes talk about how they think about cases, but not as much as we would like. For our benefit, I'd like to understand a little bit about how you think about making a decision as a judge, and what are some of the principles you pulled on as a judge when you're making critical decisions, whether it be sentencing or a critical motion or some issue at trial.
Well, I always had fairly extensive briefing, and so I worked backwards. I don't know how many other judges would do it, but I started with the reply brief, and then I worked backwards because I think the reply brief helps focus on what the key issues are. So I started work backwards. Once I read all the briefs, whatever law clerk was assigned to that case with me, I would have him come in, and I would talk to that law clerk about where I thought I wanted to go, but I gave my law clerks a lot of independent reign, and so I'd have them draft opinion, and then we'd go back and forth on the drafts, come back in, and then if we had oral arguments, would tweak the draft. Occasionally, I would flip it. Lawyers would be surprised. I wrote very extensive opinions. So my average opinion was, summary judgment ruling was probably 40 plus pages. So I tried to be very thorough. It's very important to me to write for the losing party so that the losing party knew that I had considered all of the arguments. And I think you can search my more than 100,000 pages of judicial opinions. And I don't think you'd find the word frivolous in there, because if a party raised the issue, I addressed it. I might have said it lacked merit, but I wouldn't say it was frivolous. And so, I'd work through the issues, and but the lawyers would be surprised. Once you have a solid draft done, it doesn't take that much work to flip the result because you have the legal analysis done. So you have to make a few tweaks. I didn't flip the result very often for what I thought going in, but I wouldn't flip the result, but I might change the reasoning based upon what happened in oral argument. So that was kind of how I approached it. I actually enjoyed cases where I didn't have much of a background as a practitioner. I enjoyed that more because I didn't bring any of my preconceived notions. So I did a lot of civil rights and employment discrimination as a lawyer. And so I brought a lot. I did both sides. I spent the first 7 years on the plaintiff side. Then by the time I went on the federal bench, I was 50-50, half on the plaintiff side, half on the defense side, obviously not in the same case. And I think that was a big help to help me figure out how to analyze cases, because I had that really balanced plaintiff and defense background.
When you approach tough decisions in cases, especially when the decision wasn't immediately clear on the briefing, how do you go about that process of struggling with and coming up with the right outcome when you need to do a deeper search? whether it's internally or externally?
Well, it was both internally and externally because I found that I like to do a lot of my own legal research. I was very proficient in some of the various legal research services, which I had used in the late 70s. My small law firm bought two desktop computers off an IBM promo tape that hadn't been built yet. We spent $50,000 on our two, and we immediately got legal research online. And so I've been doing legal research for close to 50 years. I think I'm really good at it. And so I can do a deeper dive sometimes than what the lawyers did. So I rarely relied on only the research that the lawyers did. Either my law clerks or I or both did our own independent research. And, depending upon the firm, but even with big law, I found that my research was often added to my analysis from what the lawyers provided. And so, I just worked as hard as I could to try and come up with the right decision based on the case law and based on how I thought the case ought to come out. I think I was known for, for example, I would have law clerks come in and say, well, this case is dispositive. This is the result you have to reach. I would read the case and say, yeah, I don't think it's dispositive. May strongly suggest how it ought to come out. But if I think it ought to come out differently, then my job, meaning your job too, is to find a way to adequately distinguish the case if we can. If we can't, and it's binding precedent, I would follow it. But if I didn't agree with the precedent, even though it was binding, I would follow it. But in my opinion, I would always indicate why I disagreed with it, but I would follow it anyway because I took an oath to uphold the law, whether I agreed with it or not. And I took that oath very seriously, because I think every federal judge I knew did the same thing. They took the oath very seriously.
On the spectrum for decision making, you've got one end where you get the briefs, you have a gut reaction, and everything tells you it should come out this way. To the exact opposite level where you don't know what should be the outcome. And so when you're in those spaces where you don't know what the outcome is, I'm curious if you can look back and determine, how did you know when you were at the point to make a decision?
I'll give you an example. 3 weeks after I started, I took over a very complex patent case for the senior judge that I replaced. And I told the patent lawyers that you could take what I know about patent law, put it in a thimble, and you'd have room left over. So in the middle of the jury trial, a federal circuit decision came down. So both sides briefed it. Here I was, I knew nothing about patent law, but I disagreed with both sides' analysis based on my reading of the case and the cases cited. And I applied analytics that were different than both sides suggested. Ultimately, it turned out when the case got appealed to the federal circuit, I was correct, but I didn't know that. I just gave it the best shot, given my legal reasoning ability to read the cases and decide what the appropriate rule of law that I should apply ultimately to the jury instructions would be in the case, which is the same whether it's a patent case or a commercial case, civil rights case. It really doesn't make any difference. You just read everything you can and make the best judgment you can. And you take into consideration the briefing of the lawyers. Usually the higher quality lawyers, the briefing was better, but I didn't always necessarily agree with that. But I gave it respectful consideration. But here's the way I looked at it. When I was sworn in as a United States District Court judge, I was the only one that raised my hand. Nobody else raised my hand. And so it was my obligation to do the very best that I could, to work as hard as I possibly could to try and get the right answer. Usually the parties were very helpful in guiding me in that direction, but ultimately it was my responsibility. Does that make sense?
It does. I'm going to push just slightly harder on this last point because
Sure.
I'm curious of, I'll put it in my shoes as the partner. I want to pursue an area for the case, but I also want to be convinced it is logically sound and is going to deliver the appropriate result, factoring in all things. To me, it feels like you iterate for a while, and then the best arguments are the ones that almost when you're skeptical at first, and then you convince yourself through the process that this is the outcome. There is no better outcome for this. And so I'm just curious if at some point it's a feeling or what it is to get you to that point where you feel confident that this is the best outcome based on the circumstances. And if it's a feeling, or if you feel like it's literally and figuratively a tipping of the scales, I think it's just curious for the viewership to know what is the feel that gets you to the end result, because we are humans through this whole decision-making process.
Yeah, we are humans, but I don't think I ever decided cases based on feelings. I decided cases based on the best judgment that I could bring to bear on an issue. And so I would read all the cases and decide what I thought was the best argument and then go with that. So I wouldn't describe it as a feeling. I would describe it as a judgment. Sometimes those judgments came easily to me, and sometimes it was a big struggle, and I would go back and forth. I was a big believer. I once argued a case in the U.S. Supreme Court where the lead opinion said there were 42 reported decisions on the question. And the lead opinion said this is a case where it's more important to decide it than to decide it correctly because everybody needed a resolution. Well, I never decided something because I didn't think it was important to decide it correctly. I did my best, but a lot of times you just need to decide it because justice delayed is justice denied. And I took great pride in the fact that I got 90% of my rulings out within 10 days of a hearing, with on average 40 plus pages of opinions, because we had worked on the opinions before the hearing.
I like it. I think it's helpful. I mean, I think it's hard for judges to have the resources or the time to write, but I do agree that the outcomes I've received in cases, even ones I didn't like, if it's written, to my point as well, I think is that it allows for the logic to flow. And if you can't write it, it's probably an indication it may not be the right way to rule. Very similar to if you can't write the argument, it's probably not a good argument. So I hear your point. I think perhaps part of it is the value of the written opinion is if it makes sense coming from your head to the paper, that's probably a good indication you're heading in the right direction.
I think so. And the advantage of written opinion, I know some judges who move their cases would rule from the bench. I did not. I'm not sure I ever did that. I might have given a kind of indication of how I would rule. Also, I never wanted proposed findings of fact and conclusions of law. And if lawyers offered to submit them, I would say, no, thank you. That's my job. I'm not delegating that to the parties. And so, I worked 80 hours a week. I worked 7 days a week. The day I started my job, I had 156 motions pending that I inherited, many of which were quite old. And we just worked really hard to get through them. But my goal was to deliver the best quality written opinions I could on virtually everything that was before me as quickly as I could do it.
You mentioned appeals, and this is something I've never had a chance to talk to a judge about. From the lawyer, we all know what it feels like to win, lose, or draw. You mentioned appeals earlier today, and I'm curious from the judge's perspective, what is it like when you get a ruling from a higher court where they disagree with what you ruled below?
Didn't bother me at all. That's why they were on the higher court. So I don't think you can ever take that personally. And sometimes when I would hand a final draft of an opinion to my legal assistant, fancy name for a legal secretary, who happened to have a law degree, I would say to her, this is probably going to get reversed on appeal because I know the appellate court well, and I think they're unlikely to agree with me, but this is my best judgment. And then if I did get reversed, I was fine with that. I think only a couple of times would I ever be kind of mildly irritated, because when I read the opinion, I would say to myself, well, yeah, I would have reached that result had that been the case I tried, but that wasn't the case I tried. So I mean, this is why they reached the result that they did, or the ruling that they did. But I never took it personally. They had a job to do it. I had a job to do. And on tough issues, close issues, you're going to have disagreement. So that's just part of the job. You do the best you can, and you let the appellate court do what they do.
A couple of things I want to touch on. We're still talking about the trial phase of your career. You've had some interesting comments about how you decided to handle trial days, the length of it, the logic, things like that. Share sort of how you evolved on that theory and where you ultimately landed on how you do a trial day when you're on the bench.
Yes, well, it was really more than just the trial day. I developed early on what I call the jury-centered approach to judging. So my guiding principle in terms of the mechanics of how to do a trial was the following. What would a juror want? Not what the lawyers wanted, not what I wanted. What would jurors want? Because I had over 400 jury trials. Not many people have tried 400 jury trials in their career. I had great respect for the Seventh Amendment on the civil side and for jury trials on the criminal side. And my goal was to make the jurors an ambassador for our court when they were done with the process. So everything I did was centered around what would jurors want. I'd like to give an example, if I may. I was trying a very complex Title VII discrimination case. Hotshot, self-proclaimed lawyer from Chicago was defending. And on the very first witness, like 3 times he asked to approach, he wanted a sidebar. And I had all the fancy white noise to do the sidebar so the jurors couldn't hear it. And every time he approached, it was a nothing burger. It wasn't anything we needed to do at sidebar. So the next time he said, may I approach? And I looked at him, I said, no, you may not. And he said, excuse me, I'm not sure you heard me. I would like to approach. And I said, no, I heard you. And the answer is no. And half of the jurors started clapping. That's when I decided I'm not having sidebars unless I see a reason for it. So I put in my trial management order, I don't do sidebars. And I'll give you an example. I tried a case that had ended in a mistrial. No, it ended in a hung jury in the Middle District of Florida. I helped out a lot of other districts. I had over 500 cases in Arizona. I've tried cases all over the country, including the farthest reaches of the federal court in the District of the Northern Mariana Islands in Saipan, where I was a visiting judge for 2.5 years. I would fly over there and do all their civil and criminal trials. So when I got the transcript of this trial that had ended in a hung jury, I noticed that there were, I had never seen so many sidebars in my life. And this was after I developed my philosophy of no sidebars. So I sent an email to all counsel in the case saying, I counted it up, I don't remember, it was like 87 sidebars. I said, on the retrial of this case, there will not be a single sidebar unless I request one. And they were kind of shocked. Guess what? We didn't have a single sidebar unless I requested it, because it offended my Midwestern sensibilities of courtesy to have this private conversation while the jury's in the box. Now, very rarely, if I thought there was something we needed to discuss outside the presence of the jury, I might send the jury out on a short break, but very rarely. Because 99% of what lawyers wanted to raise at sidebar, they could, one, if you told them there would be no sidebars, they just didn't raise it because it wasn't important. And one thing that impressed me was after my no sidebar rules, on the next break or after we sent the jury home or the next morning, they never raised what was so important that they thought we needed to have a sidebar, right? So it really wasn't very important. And it just made the trials go faster and a more pleasant experience for the jurors. Because if you're on a jury, do you think you enjoy sidebars? Do you think you enjoy 5 or 6 sidebars a day? I don't think so.
Yeah, I think I would feel like a child where why are the adults speaking outside of my presence? Which I think we don't think of it that way, but I hear your point on that front, and it makes perfect sense. How about for trial length, as far as the amount of hours in a day? What was your thought process or evolution on how long should be the trial day?
Well, I had this notion that rather than going from 9 to 5, because our jurors came predominantly from rural areas, they would have to drive 100 miles. Some would drive 100 miles each way. They had the option of staying overnight, but a lot of them wanted to get home to be with their family. And so I thought, what would be a more jury-friendly trial day that would be as close to being as efficient as a 9 to 5? So I started with this 8:30 to 2:30 schedule. And because I had real-time court reporting, I could keep track on the number of transcripts, the number of pages of transcript. And I found out by taking 2 20-minute breaks, one mid-morning and one mid-afternoon, not having a lunch break, but providing healthy food for the jurors when they were on their 20-minute break, and not healthy food. They could have their choice between donuts and fruit and healthy snacks, and we provided beverages. That it was just as efficient as a 9 to 5, but yet the jurors could leave at 2:30. They could be home sometimes in time to pick up their kids from school. If it was a stay-at-home mom or stay-at-home dad, they could cook dinner for their family, and they were just fresher. And people in the Midwest are used to getting up early, so they didn't mind starting at 8:30 in the morning. What they didn't want to do, particularly in the winter, was leave the courthouse when it was dark out and drive 100 miles when it was dark. And so I adopted that schedule. It also, we had, I know it's hard to believe, in the Northern District of Iowa, we had the 5th heaviest criminal caseload in the nation for most of my tenure. So, for example, I would sentence more defendants. If you took a federal district court judge from the District of Columbia, the Southern District of New York, the Northern District of Illinois, Chicago, the District of Minnesota, and the Northern District of California, San Francisco, and you added them all together, I sentenced more defendants than they did. And so by going 8:30 to 2:30, it allowed me to give my court reporter a 30-minute break and then start sentencing every afternoon during a civil or criminal trial, and allowed me to keep my docket moving, which was important to me.
On trial advocacy, one of the best parts about being a trial lawyer is you have the ability to present your case basically any way you see fit within the bounds of the law, which is exceptional. What I'm curious about, because of the vast majority of cases you saw and just the sheer numerosity, I'm always interested in creative ways that people don't think about presenting trials. I'll give a prime example of one that gets lost. you don't necessarily have to, as a defense lawyer, present an opening argument at the end of the plaintiff's opening or the government's opening argument. Theoretically, you can wait till partway through the case and then present. It's something that is so obvious as an option, but so unclear because people don't know about it, don't see it. I'm curious as far as things you've seen that were outside the norm that worked. And why don't we start there, and then we can obviously figure out what didn't work. But things that were outside the norm that worked would be of particular interest to our viewers, since we don't have the ability to be in trial or in court as much as you were.
I think generally it was a mistake to reserve an opening statement for the defense in both a civil case and a criminal case. I can think of maybe one or two times where in a criminal case, the defense lawyer wanted to see how the evidence would come in, because for those who don't practice federal criminal law, you don't get to take depositions. You don't know. It's not like a civil case where everybody is way over deposed, in my judgment, and you ought to know pretty much how the case is going to come in. In a criminal case, you don't know that. So sometimes it might be best to reserve it. But because of primacy, I thought it was almost always better to give an opening statement immediately following the government, even in a criminal case, unless there was something you really needed to see what would happen and you were a little bit unclear which maybe alternative defenses you might use. But generally, I thought reserving it was a mistake, because jurors often make up their mind. I don't know. I shouldn't say that. They don't make up their mind. They have a leaning. And so if they can lean in to the one side that gives an opening statement and have to wait for the other, particularly if it's going to be a long trial, I think that's a high risk act.
How about, have you seen any high risk acts that did pay off, even if perhaps you didn't think they were going to at the time?
Yes. It was a product liability case where the defense lawyer gave an 8-minute closing argument. The jury was out a little bit longer than that, but there was a defense verdict. But it was a really good 8 minutes. It was 8 minutes, really did not go through the evidence. You know how lawyers say, I'm not going to go through all the evidence, and then they proceed to go through all the evidence. I mean, that happens all the time. This lawyer said, I'm not going to go through all the evidence. Here are my 3 themes. Went through his 3 themes, sat down. And one of his themes was there was a consortium claim. So he got to the consortium claim, and this is all he said. I put into evidence the diary of the spouse. And I'd like you to turn to page 16 of that diary and read it. That's all I'm saying about the consortium claim. That's all he had to say. Plaintiffs didn't win on any claim, let alone the consortium claim. You know, you don't think of an 8-minute closing argument after a week-long trial as something that most lawyers would dare to do, but it worked great.
That's helpful. I like it.
And I think the jurors were so impressed that this lawyer didn't waste their time. Because I did something, Adam, that I think every judge should do. I prepared a juror evaluation form. So I would tell the jurors, a jury selection, that at the end of the trial, they were going to get to evaluate pretty much everything about the trial. The lawyers, me, the jury instruction, the food that we give them, the cookies that I will bake for them on their last day of jury selection, whether they liked them or not. And that helped empower the jurors to know that I was concerned about what they thought. And the number one critique of lawyers on the jury evaluation forms was, I'll summarize it, but it was always some variation of this. They were too repetitive. We got it the first time.
I think that's a fair point. And you're right. I think you see always overemphasis on issues in a trial. And, I think we somewhat doubt the collective knowledge of the jury veneer, but it's amazing. Every time what they come back with, the collective knowledge seems to capture almost all the information, even though you're bombarding them with two different competing theories and all this information all at once.
The collective knowledge of jurors is unbelievable. It is so wise. And at least in the Midwest, jurors take their responsibility, particularly in federal court. I mean, I operate in this beautiful federal courtroom, old Art Deco courthouse, 28-foot high ceilings, beautiful courtroom. When they walked in, they were impressed by the majesty of the courtroom and the importance of the proceedings, and they took it very, very seriously.
I do want to switch. We teased out at the very beginning, you obviously have switched to mediations and arbitrations and done a sizable amount. So I want to get into that chapter of your arc. And I'm going to jump right in to the AI piece because it's interesting. I want to make sure we have enough time for it. And then we're going to get to a few other points there. On the AI piece, I saw recently you used it in an effective manner. I'm curious from your perspective, when you started playing in that pool and how you've seen certain effective ways to use AI so far in your alternative disputes practice.
I have not used it extensively. I have sometimes fed in information from both sides from their mediation statements and asked for questions that I should be asking. I didn't find that all that helpful. They were questions, some I thought not so good. Others, I would have asked better questions anyway. But it was interesting, and I'll probably continue to play with it. Part of it is I probably need to do better prompts. I kind of get that. But I had this mediation very recently where I had a very unsettled issue of law, of state law. And each side could not find any authority to support their position because there wasn't any in the particular state that this case was being mediated in. So I thought, I would like to know the answer to that question, particularly because if I thought it came out the way I thought it likely would, I thought, given how smart the plaintiff's lawyer was, but how unrealistic he was about the likelihood that he was right on his interpretation, that if I can convince him otherwise, it would have a dramatic impact on his typical too high demand. And so I did. I used AI. I could have done it myself on Westlaw, but it would have taken me a long time. And I don't bill for my research on cases. I just do it because I'm naturally curious. And sometimes it helps the lawyers when I can weigh in on a legal issue. And so I used AI. And then it came up with the kind of split nationwide, the majority view, the minority view. I checked the lead cases because I was skeptical. I think being skeptical is the best trait I ever brought to the bench. I'm skeptical of everything. And so once I had a good grasp on it, I was able to use that at the appropriate time in the mediation. I shared the information that I printed out with the plaintiff's counsel, and he realized that, and we had a nice discussion about it. He realized that his likelihood of prevailing on this issue, he thought he would, was more remote than he had originally thought, which is understandable. And it dramatically affected his demand. And we were able to get the case resolved. I mean, for a boatload of money, he and his client came out very well, but it would have been difficult without that information to get it resolved. So I'm going to explore ways to use AI. You know, I'm 70. I'll be 76 years old in June. I'm at the end of kind of my legal career, and so I've been hesitant about leaping into AI. I'm curious about it. I don't really have the time, but I'm going to make the time, and I think I'll find ways to use it. I'm not exactly sure how that's going to play out, but I'm not going to give up my 50 plus years of experience and my independent judgment because AI says I ought to answer this question. This is a good question that I haven't thought of. You bet. You bet. I'll take help from anywhere I can get it.
I think it's all about the framing of how you use it, because I'm very into it, but it's an augmenter. It's not a substitute by 100%. But if you don't think of it as just a Google search, but you think of it, for example, as how you use clerks, right? I'm guessing you probably use them to sometimes just socialize your ideas to see if they landed, if the logic was there. I think you would find in that piece it's good. I will give you one little thought process that you might want to try. Most AI tools are really good at talk to type, which is funny because it's taking it full circle to dictation, which, regardless of how antiquated that appeared at one time, I think it's back in business. What's also funny about it is I think dictation helps you see, am I explaining myself clearly? Because if it comes out of my head and it writes the way I think it is, you're probably thinking literally. But try talk to type with it and then do back and forth. And also, there are different mechanisms where you can have it speak back to you in a voice. I think at your level where you've already know where you want to go on issues, but you want to have a thought-provoking piece. And I'd almost argue for someone of your level, the best part of it is there is no reverence. There is no deferral as far as you are the best, which is interesting. I love it. And this is my last little sort of soapbox moment on this, but as you get more senior in practice, it's harder and harder to get critical feedback because the institution that we are in doesn't really align that way. I think it'd be curious from a judicial perspective or a former judicial officer. I think you will get pushback in ways you haven't gotten, perhaps in a long time, but it may also open up some thinking as well.
Thank you for that. I really appreciate that. And I think critical feedback is super important. Super important. And one of the things I did with these jury evaluation forms that I talked about, we would send them out to, after the jury came back with their verdict, I would go down and meet with them in the jury room. I would debrief them, answer any questions that I could answer. I would then ask if they would be willing to have the lawyers come in to talk to them separately. And then I would hand them the jury evaluation forms, tell them that we've made all kinds of changes in how our court does business based on the feedback we get. I would appreciate the feedback. And they had a chance to evaluate all of the lawyers, both on objective questions that I had in the form and on open-ended questions. And then when those came back, we got a 90% return rate. I gave them to them in a stamped self-addressed envelope. I told them that the lawyers were very interested in improving their craft, and this is the best thing that they could do to help the lawyers improve. Then when they came in, my legal assistant would take that portion for each lawyer and send it to them. They wouldn't get to see what the jurors said about the opposing counsel because I thought in today's advertising age, they would use that in their marketing. And I didn't want them to do that, but they would each get their own feedback. And the lawyers really appreciated that because they got great feedback from the jurors.
I also want to pull on with your mediation practice. One of the things I struggle with is the quality of both the mediator and the participants in the mediation. And I think on one extreme, you have both sides advocating for their positions, and the mediator serves as a conduit to get the information passed. But that's really not super effective for either the lawyers or the mediator or the client in that respect. The other end of the spectrum, it feels like you have these mediators that are very heavy handed and just hammer both sides, which can also have an equally problematic effect. Those are the two extremes I see in mediation. And then the last thing I'll say on that point is you then couple that with what I would describe as a very classical negotiation style by most sides, which is start low, anchor high, work to the middle, work down the other side. When you mix all those things together, what should be an effective process becomes hopelessly ineffective. So I'm curious, as someone who's clearly taken a fresh take on things, how do you address those various concepts and make a successful mediation when we're walking in with this construct that just really invites the complete falling apart of the process?
That is really a terrific question, Adam. And when people contact me about hiring me, I tell them that if they want a facilitative mediator, I have a pet parrot, Lucy. She's very good at facilitative mediation, and she charges about 25% of what I charge, and they can hire her. And they laugh because it's kind of funny. And I tell them that I don't like facilitative mediation. I'm not very good at it. If they want a true facilitative mediator, they don't want to hire Lucy. I'll give them the names of some mediators that I know who do a really good job at facilitative mediation, but I don't like doing it. I don't want to do it. Now, on the other hand, I do evaluative mediation, and people hire me because they generally trust and want my evaluation. But you can't be heavy-handed in an evaluation. And so I think I have the temperament of a facilitative mediator, but the judgment and experience of an evaluative mediator. And I ask at the beginning of each mediation, even though when they hired me, I made it clear, if you don't want my evaluation, you need to tell me that when we get into our breakout room or our caucus room, because I've been evaluating cases for 50 plus years. And as soon as I get information, I start evaluation. And I want to evaluate the case, but I want to discuss it with you. It doesn't mean that my evaluation is better than your evaluation, but it's a different set of eyes looking at it. And I think I probably had more trials than most of the lawyers I work with, than most of their law firms combined, all the lawyers in it. So I find that people want my evaluation, but you cannot be heavy-handed about it. You just can't, because it doesn't go down well. So you have to blend the approaches. I had a very recent mediation on a Saturday, and very, very good lawyers on both sides. And I had mediated with the plaintiff's lawyer before, never with the defense lawyers from, I would say, kind of, I'm not sure, big law, big law, excellent trial lawyers. And they said afterwards that they were surprised for a retired federal judge how affable I was. But I try and be affable because I like to connect with their clients, which is important. And you can't be heavy-handed. Nobody wants to be told what to do. Think about it in your own personal life. If you have a spouse or a friend, nobody likes to be told what to do. They like to be guided. Well, here are the pros, here are the cons. here's kind of where I'm leaning, but I'm interested in what you think, not only about what you've told me, but what you think about what I've just said, and get feedback on what I've said. But I think the problem with a lot of retired judges is they're used to telling people what the result ought to be. And so they want to do that in mediation. It's a completely different skill set. And I think the really good retired judges understand that the skill set for mediation is completely different than being a judge. And if you can't make that transition, sure, I'm sure some people will hire you. I don't think you'll be as effective of a mediator as you can be if you don't see the differences. Does that make sense?
It does. And I would even take it a step further to say, if you think about the best closing argument, you are empowering the jury or the finder of fact to want to rule in your favor rather than overpowering them to that outcome. And to me, the way you're describing it is somewhat similar to that, because you know you're fighting two combative forces who have spent a lot of time and money. And so putting more fuel on the fire, generally speaking, isn't going to work unless one side is likely broken to the point that they're just looking to end this thing. But if you have a true set of adversaries that can go the distance, short of logic and idea adoption, you don't have those other tools are going to be ineffective, in my view.
Yes. And in a recent mediation I had, I was so impressed by these very sophisticated trial lawyers. In the mediation, they kept saying to me, what can we do to make your job easier today? Not many lawyers ever ask that question. It was really interesting. And I had a bunch of different suggestions. And they were very, very receptive to it.
I'd like to finish on something that I'm very focused on. I always describe the practice of law, especially in private practice, as living on Mars, meaning you're really not built to survive here, but we do it. And I've definitely, after I hit the 15-year mark, I focus a lot more on thriving in the environment, but that's not the legal aspect. That's the other parts of it that make you a fully well-rounded, healthy human. And I think that gets lost. And I think you've also started a generation, perhaps that didn't even consider these things, but clearly you have a longevity to it. And other than just, it's great. It creates intellectual stimulation. I'm curious about some of the physical things you've done over the years, or how you keep coming back to it in a way that you can thrive rather than it be a hindrance on your health or your mental well-being.
Yes. It's kind of strange. I'm just wired to work hard. I always have been. And so last June 4th, I turned 75. And my daughter called me that evening, 35-year-old daughter. She said, Dad, what'd you do for fun today? And I said, Sarah, I did a 12-hour arbitration. And I said, it was one of the most interesting things I've ever worked out. And she said, Dad, you're hopeless. And I said, Sarah, you're right. I am. But I had a great day. Couldn't think of a better way to spend my 75th birthday. Now, that evening, it was late. My spouse of 48 years and I went out for dinner. So I used to work out a lot, particularly when I was a judge. I would work out at 5 o'clock. I'd go to the courthouse, usually between 3 and 3:30. And then I'd go to a gym and work out at 5, from 5 to 6. And then I'd go home and take my daughter to dance practice. She was on a dance squad, and then go back to the courthouse. So I tried to, it's very important to meet your family obligations. My daughter turned out to be a pretty good collegiate tennis player. And I wanted to make all her high school matches. She went away to college, so we were able to go to some of the matches. But I tried to get the schedule ahead of time so I could attend as many of her high school tennis matches as I could. but I was able to combine I still work. My average work week is still about 70 hours a week, but I'm usually up between 3 and 3:30. I don't set an alarm. I just wake up and start working. I've got a great home office with multiple screens, 2 high-speed printers. But I also enjoy a few hobbies. So I don't have as many hobbies as some of my friends, but I love to work. I find it very fulfilling. And I think whether you have a hobby or work, if it isn't fulfilling, you ought to try to find something else to do. And I love helping people. So, I want to give you an example. I got a call very recently, and it was from a lawyer that I didn't know. And they wanted to know if I'd be willing to be what's called the referee or a state court partition over real estate action. And here was the dispute. This lawyer and her niece, who she's estranged from, owned a home, and they couldn't agree on which realtor to use to sell the home. The niece hires a lawyer. They file a partition action because they can't agree. She wanted to know if I would decide this for them. And I said, it's a little bit of overkill, and you can't really afford to pay me to do it. So here's the deal. I'll do it, but I'm going to do it pro bono because it's only going to take me about 30 to 40 minutes, and you need a decision. And rather than have you go to somebody else and start the whole process, you tell the other lawyer you can have the state court judge appoint me as a referee, and I'll decide it. Because I'm going to help somebody solve a problem, and I can do it very quickly. That's my passion in life, and I find that really fulfilling. I'll have more fun deciding that for him and deciding it quickly than if I went out and went to a comedy club for an hour.
It certainly fits that belief that, if you do what you love, you'll never work a day in your life. And
yes.
I think that's true for lawyers, notwithstanding some of the stereotypes there. So I think that makes perfect sense. And it's funny, it reminds me, I'm getting ready to start a significant case. And at this point in my vintage, my mindset is what's going to happen during this case. I've had cases where I've gotten married and had a kid because the case lasted 2 or 3 years. I've had life events where I've moved twice during an episodic long haul case. And I think that's the sweet spot, is when you get to the point you can be selective in what you do. This is a journey, and each one at this point of my career, where one way or the other, I look at it, maybe I've got another 15 years, maybe I have longer, but I'm presumably about halfway through-ish. And each case is a new adventure. And I look at these as gifts where I'm going to learn a lot about myself during the process. But I think all that enthusiasm helps make the new case that exciting. And then you start to look at these life arcs, and it's ways to measure life in different ways. But it's if you can get to that point, there's not a better profession in the world, I don't think.
I agree. And I haven't preached much to my daughter, but I told her the key to a happy professional life is not ever having a job. I was a trial lawyer, I was a judge, and now I'm a mediator, arbitrator, and legal consultant. I've never had a job. I've had a calling. And I've loved everything I've ever done. And when I've given up one thing, I've never looked back. I've never once regretted giving up my practice to be a judge. I've never once regretted retiring from being a judge because I love what I do. And as long as I have a full plate, I'm happy.
Well, Judge, thank you for coming on to Disputes and Perspectives today. You've certainly filled my cup, and it's a real testament to see how longevity in the game can just lead to bigger and better things. So I appreciate you so much for coming on, and certainly I know our viewers will appreciate what you said, and certainly they can track you down online as well for your mediation services. I really appreciate you coming on to Disputes and Perspectives. Thanks you, Judge Bennett.
Well, Adam, thank you so much for having me. The time went by like that. Thank you.
I promised you it would.
Yeah, you're right. You fulfilled your promise. Thank you so much.
Thank you, Judge.
day.
Disputes in Perspective is a Reed Smith production. This podcast was produced by Shannon Ryan and edited by Julian Bachman. For more information about Reed Smith's litigation and dispute resolution practice, please email disputesinperspective@reedsmith.com. You can find our podcast on podcast streaming platforms, reedsmith.com, and our social media accounts at reedsmithllp. This podcast is provided for educational purposes. It does not constitute legal advice and is not intended to establish an attorney-client relationship, nor is it intended to suggest or establish standards of care applicable to particular lawyers in any given situation. Prior results do not guarantee a similar outcome. Any views, opinions, or comments made by any external guest speaker are not to be attributed to Reed Smith LLP or its individual lawyers.